Good afternoon, everyone. It's a pleasure to be here and discussing a subject that is near and dear to my heart, that is appellate procedure, or as I affectionately refer to it, how to clear a room in 30 seconds or less. It can be a dry subject, but hopefully my enthusiasm and love for the subject will come across during the presentation. First, let's start off with just some background about myself before we get into the material. I've been with Bradford Barthel for almost 15 years now, and I'm a partner with the firm, and I head up the firm's appellate division. And we formed that division in 2008 or 2009, shortly after my involvement, along with Don Barthel's, in a little case called Guzman. And that, of course, is the case from Alvarez Guzman fame. And Don and I worked on that together and took that all the way up to the 6th District Court of Appeal. And in that same year, I handled a case called Cervantes, which many of you may know as the second opinion spinal surgery case, which is thankfully no longer the law, thanks to changes brought about by SB 863. And so after that, I was kind of bitten by the appellate bug, and don't worry, it's not contagious. From there, formed the division and have been handling writs, recons, appeals to the Supreme Court, which I file numerous pleadings with the courts of appeal, with the Recon unit, many times a year. And most recently, I had the opportunity to argue before the Supreme Court on March 3rd regarding a death case and what the correct standard is in California workers' compensation death cases. That decision is still pending, and I am eagerly awaiting the outcome of that case. So with that, let's go ahead and dive right in. We'll start with the first level of appeals, which is a petition for reconsideration. And the standard is the same for writs. Any party who is dissatisfied with a final order from a workers' compensation judge may seek review of that order by filing a petition for reconsideration. And a final order is really the key threshold. And we'll talk a little bit more about what a final order is and what a non-final order is. A final order is essentially one that finally disposes of a substantive right in the matter. So an issue that decides one's entitlement to permanent disability or temporary disability or medical treatment, or the existence of an MPN, those would all be final dispositions. A non-final, in contrast to that, a non-final decision would be something that affects a preliminary or interim issue, like a discovery right, the correct panel specialty. Those would all be non-final orders. And the reason that's important is because it affects what your appellate recourse is. If it's a final order, then you can file a petition for reconsideration. If it is a non-final order, then your remedy is a petition for removal, and we'll talk about removals in a moment. Decisions on reconsideration of the appeals board are appealable by petition for writ of review with the Court of Appeal or Supreme Court. And what actually Labor Code Section 5950 stands for is that a party that is aggrieved by a trial decision actually has the right to file directly with the Court of Appeal. However, that is very rarely done, and in fact, I've never seen it done in my time practicing workers' compensation. And more often than not, what would likely happen if that were done is that the Court of Appeal would send it back down to the WCAB to get their take on the dispute, because that higher court would defer to the WCAB's opinion on the matter first, and before they granted review of such a dispute. Now, what does it mean to be aggrieved? 2 points here. Any person aggrieved directly or indirectly by a final order, decision, or award made by the board, or WCJ, may petition the appeals board for reconsideration. And to be aggrieved, you must be a party to the matter. And so that can be a claimant, an applicant, or a dependent in a death case, or the employer or carrier. The employer directly would be, or an example of where an employer would directly be a party to the matter would be a 132A or a serious and willful dispute, or a lien claimant once the case in chief has been decided. And probably one of the most important things about petitions for reconsideration is the time frame. Again, it requires a final order from the judge, and prior to the advent of EAMS, a party would have to file their petition for reconsideration at the board that decided the case. However, thanks to EAMS, we can now file anywhere at any board or with the Recon unit directly. And as I mentioned just a second ago, the most important thing is the time frame, because if you blow the timing, then you are completely out of luck. That 20 days plus 5 from mailing is jurisdictional, meaning that the WCAB will lack jurisdiction to address the issue if the petition for reconsideration is not timely filed. And it's not sufficient if it's only mailed within the statutory period. So if you're not e-filing and you're mailing it in on the last day, you're out of luck. It has to be received by the board within that 20 days plus 5 for service. And you get that 5 days even if it's e-filed on, or if it's served on you via EAMS. And what that means basically is you have 5 days from the date that it's uploaded into EAMS and sent to you, plus an additional 20 days thereafter to file your petition. And very important as well, it's not only specific as to the number of days, but it must be filed in EAMS. Let's say you're filing on the last day. It must be filed in EAMS by 5 o'clock that day. And when you file a document in EAMS, you get a timestamp. And if that timestamp shows 5:01 on the last day, it's untimely. So some additional formalities of service. It must be served on all adverse parties. And what that means is essentially if you are disputing a temporary disability issue, for example, and there is an EDD lien, EDD is potentially an adverse party, and so they must be served with that petition for reconsideration. Likewise, if you're disputing a medical treatment issue where there could be medical liens down the road, that provider or all of those medical providers that could be adversely affected by the outcome of the decision should be served as well. And one final consideration in terms of formalities of service, a proof of service is required. Failure to provide either of those, a proof of service and service on all of the adverse or potentially adverse parties, can be fatal, meaning that the board can dismiss your petition outright. Some other considerations in terms of the format of the petition for reconsideration or petitions for removal as well. Regulation 10,840 governs what can be or what must be included in a petition for reconsideration or removal. Both of them must provide a fair statement of facts with citation to the record. This regulation also includes specific citation format when you're referring to specific exhibits in the record. There is a page limit. Also, it must be under 25 pages. If it is over that, again, it can be dismissed. You can get yourself sanctioned. One other good way to get yourself sanctioned is to file exhibits with your petition. The court or the Recon unit will have access to all of the trial exhibits. If there was if there is documentation that you thought was important, then it has to be in the record, for the trial record, for the Recon unit to consider it. And there's one exception to that, and we'll talk about that in a moment. And then the board discourages filing of supplemental petitions. So if you file a Recon and the judge issues his report and recommendation, the other side files an answer, and you think there are issues raised that you want to address or rebut, you can file a supplemental petition. And it's disfavored, but when I've done it in a handful of instances, the supplemental petition has been accepted. And so when you're filing it just to argue a point that's already been argued, there's really no need to do so, and the court will more than likely disregard that supplemental petition. If there are issues newly raised, in the cases where I've done it personally, the judge raised an issue in his report and recommendation that wasn't in his findings and award or opinion on decision, and so I felt it necessary to address that and rebut that, and did so, and the board accepted our supplemental petition in that situation. And when you do that, you have to request permission to do so, which you can just put at the beginning of your supplemental response. Now, in terms of grounds for reconsideration, there are several statutory grounds, and these are the only grounds under which the WCAB can exercise jurisdiction on an appeal. And one of those, the first of those, is the board acts in excess of its powers. Labor Code Section 5903 states that the first ground for granting reconsideration is that by the order, decision, or award made and filed by the appeals board or workers' compensation judge, the appeals board acted without or in excess of its powers. And that's, again, kind of a jurisdictional argument. We saw a lot of that with the before Dubon with regard to the IMR and UR procedure, arguing that the board didn't have jurisdiction to decide that treatment-related dispute. And so if you were filing a recon on those grounds, you would have done so under this first point. The second ground for reconsideration is fraud. The petition must make specific and detailed offer of proof with regard to that fraud. The third ground for reconsideration is that the finding is not justified by the evidence. And this is one of the more typical grounds for filing for reconsideration. More often than not, this is the one you'll proceed under. That the evidence does not justify the findings of fact. And in that petition, you have to specifically set out in detail how that evidence fails to support the findings. And conversely, you need to show that there is evidence that is more substantial, ideally, that would result in a different decision. If you don't do that, what you're more likely going to get is a remand for the board to, or the trial judge to develop the record. And one other ground for reconsideration is the discovery of new evidence. The petitioner, according to the statute 5950, the petitioner has discovered new evidence material to him or her, which he or she could not, with reasonable diligence, have discovered and produced at the hearing. And so that's the standard. If you, and this is the one exception I mentioned previously to the exhibits prohibition. If you are filing a petition on the ground that there is newly discovered evidence, then your petition must state and include the identification of new witnesses, what their potential testimony would be, a description of any documentary evidence, and probably more importantly, the effect that evidence will have on the record and the prior decision. And then probably just as equally important, an explanation as to why that evidence could not have been discovered or produced prior to the submission of the case. And that's really probably, even though it's last, it's probably the most important one, because that's the first thing that the Recon unit is going to examine as to why this evidence could not have been discovered or produced prior to submission of the case. And so that's the big burden, the threshold inquiry that a party has to meet in order to have reconsideration granted when you're arguing newly discovered evidence. And then finally, the final ground for reconsideration is that the decision is unsupported by the findings. And that's typically where there's a mistake, essentially. Again, it's not a ground that I typically see or use in my own practice when filing for reconsideration. But from time to time, judges are human, they're not infallible, and they do make mistakes. And when there is a mistake, this is the ground that you would file under to challenge that. Parties often allege that this ground, or allege something along these lines when they feel the decision of the WCJ mistakenly relies on the adverse party's evidence rather than their own. Oftentimes you'll see them challenge a decision when there is a clerical error, when the judge awards TD that at a rate that is completely unsupported by either side. This would be the grounds under which you would appeal. Now, once you have filed your petition for reconsideration, a number of things can happen. So you file your petition. The judge can modify his opinion. He has up to 15 days from the date that you file the petition for reconsideration to either reconsider his own opinion and modify it accordingly, at which point a new time limit, a new 20 days plus 5 for mailing begins to run from the date of that new decision. And secondarily, once you file a petition for reconsideration, the judge can rescind his or her decision. And when they do so, they have to order further proceedings, and they have to do so within 30 days from the rescission of that decision. And when they rescind, it's basically making it null. It's of no effect, and so it's as if the case had not yet been submitted. And usually you see that happen when there are mistakes in the decision. If you're appealing under that fifth and final ground for reconsideration, the judge will usually rescind and set the matter for a status conference and have the parties address the issue, give their viewpoints, and then usually resubmit at that point. Next, the next thing a judge can do, and typically what they do is issue their report on reconsideration. That's called a report and recommendation on reconsideration. And sometimes they will, or more often than not, they will deny or recommend that reconsideration be denied. And that, of course, is just the judge's recommendation to the Recon unit. It's not a final decision on the appeal itself. But one of the other things that they can do, if, let's say you raise 3 issues, and one of those issues the judge agrees with, and he can recommend a denial on points 1 and 2, but also recommend that reconsideration be granted with regard to point number 3. And sometimes we see that happen on occasion. And then finally, the WCAB can grant the petition or deny the petition. And they have a time constraint for doing so. It's 60 days from filing the petition or if they fail to act, it's denied by operation of law if they fail to act within those 60 days. And that very rarely happens. In fact, I don't think I've ever seen it happen in the time I've been practicing. And more often than not, when they are under the gun and can't get to a final decision on the matter, they will issue what I call a pro forma grant, where they just issue a decision or an order granting the petition strictly to meet the time constraints set forth by the Labor Code. And then at that point, they have no time constraints to issue a decision. I've had a case sit up at the Recon unit for over a year before the WCAB got around to issuing a decision on the merits of the appeal. And thankfully, that is rare. As mentioned in that matrix, a judge can amend, modify, or rescind a decision or order. When they rescind or modify a decision within 15 days of a filing for a removal petition, excuse me. And then upon rescinding the original order or award, the rule requires further proceedings to be initiated within 30 days from that order rescinding. Just further review here. Simple modifications or amendments to an order, decision, or award do not require any additional proceedings. And the distinction there is clerical versus substantive. If it is a purely clerical error, for example, the judge awards temporary disability for 105 weeks. That is very likely a typographical error, or he misspoke, and so that would be something that you could get corrected either just by simply sending in a letter to the board and requesting that the judge issue an amended findings and award consistent with the law. If it affects a substantive right, if it affects, for example, a defendant's obligation to provide medical treatment or enlarges the value of monetary award, be it permanent disability, death benefits, or temporary disability, that is a substantive modification, and that will require a petition for reconsideration. You cannot get modification of a substantive issue by simply writing to the court and requesting that it be amended. A rescinded order requires the judge to issue a decision on all issues originally raised and not just those raised in the petition for reconsideration. In other words, the clock starts anew once the judge issues that amended award. And then an answer for reconsideration may be filed within 10 days of the original petition. And you actually get 5 days for mailing there as well, although the statute isn't really a model of clarity on that point. But it's basically assumed that once the petition is filed, you get the 5 days plus the additional statutory 10 days to file an answer to the petition. And when I've sat and I've listened to members of the appeals board in various seminars, more often than not, they express or they urge parties to file answers. I know applicants' attorneys typically, or many typically, do not file answers to petitions for reconsideration, simply relying on the judge to support their decision. But the appeals board, when I've sat and listened to them, the commissioners have expressed their desire to hear the other side's point, and the points that the other side has to make may not necessarily be all the same ones that the judge makes. And so it's in your best interest to file an answer when a petition for reconsideration from a favorable decision has been filed. So that's it for recons so far. We'll talk about the board a little bit. The recon unit of the appeals board is made up of 7 members, 5 of which are attorneys, and they serve for 6-year terms. The appeals board is made up of 7 members, and all of whom are appointed by the governor to 6-year terms. They all carry the title of commissioner, and one, the leader of the group, if you will, is designated the chairman or chairperson. And when you file a petition for reconsideration, the Recon unit isn't actually a part of EAMS, so a legacy paper file is physically sent to the board. Although I think more recently they have been able to access the records electronically through EAMS as well. And every file then gets logged in by the control unit at the Recon unit, and each case is assigned to a panel of 3 commissioners for a hearing and consideration and decision. One exception to that is in bank decisions, or en banc, if you're French and you're snooty. With an en banc decision, the commissioner decides that the issue is, or sorry, the chairman decides that the issue is of such importance to the legal community that it warrants the attention of all 7 commissioners. And that was the case in Alvarez Guzman. It was the case in Cervantes. It was you saw that again in Dubon most recently. And the reason that's important is that in-bank decisions are binding authority on all of the WCAB panels and trial judges, which means that they have to follow that in-bank decision. In contrast to that, a panel decision is in no way, shape, or form binding on a trial judge. It is purely persuasive. So a trial judge can follow a panel decision, or he could go contrary to that decision. Now, when the board is dealing with a petition for reconsideration, they can do a number of things. They can grant or deny reconsideration. More often than not, they will deny it, just adopting and incorporating the trial judge's report and recommendation. Or, conversely with that, they can issue their own substantive decision. They are invested with authority to rescind, alter, or amend the award made and filed by the appeals board or the workers' compensation judge on the basis of the evidence previously submitted in the case, or may grant reconsideration and direct the taking of additional evidence. So they can also remand the decision back to the trial level with instructions, more often than not, to the trial judge on how to proceed in light of their decision. And as stated previously, under Labor Code Section 5909, the Appeals Board has 60 days from the date of filing of the petition for reconsideration to issue a decision. If they fail to do so, it can be denied by operation of law. And again, that's something that I don't think I've ever seen happen in my career. Let's move on here. Some other considerations when dealing with, let's say, with regard to that first bullet point, we refer to a reconsideration of the reconsideration, and what that means essentially is when there is a trial decision. Let's say at trial you're the aggrieved party, and you file a petition for reconsideration. Congratulations, the board agrees with you and reverses. Well, now the other side is newly aggrieved by that new decision. They have 2 options at that point. They can file a reconsideration of that decision, or they can file a petition for writ of review, and those respective timeframes would still apply. So in this example, the Recon unit reverses, you have 20 days plus 5 for mailing to file your petition for reconsideration of that decision, or you can file a writ, which we'll talk about in a moment. Gives you 45 days from that decision to file. And when we were in the midst of the Alvarez-Guzman dispute, that was a point of contention between defendant in the Alvarez case, Skiff, and our office as to whether the board's decision was final. And Skiff opted to file a reconsideration of the reconsideration, and we filed a writ. And when the WCAB granted state funds reconsideration of the reconsideration and took the case back to itself, the 6th District Court of Appeal, where we filed our writ, dismissed our writ, but not but allowed us an opportunity to respond to the WCAB's decision. And once the WCAB issued a final decision, a second final decision, the clock again began running with regard to the option to file a writ, which State Fund and my client in that case both did. One other thing that I wanted to point out, which isn't a petition for reconsideration at all, but it's something to know. It's a very effective tool when it can be used, and that is a petition for emergency stay, and that is authorized by Regulation 10,281. And what that is essentially it's not an appellate document at all, but it is something procedurally that I found to be very effective in getting an applicant's attorney to stop doing something that I didn't want them to do, which typically the scenario that I've used it in, I think, predominantly are those situations where the applicant's attorney requests 5 panels and 5 panelists issue, and before I want my client to have to pay for those 5 evaluations, I usually ask them to hold off. If they refuse to hold off in setting those 5 evaluations, I will file a petition for emergency stay, which has to be served on the opposing party no later than 10 a.m. of the immediately preceding court day. And that notice that accompanies that petition must state the nature of the relief, give the date and time and place that the petition will be heard, and then you go down the next day and you argue why the applicants or the opposing side's actions should be stayed. And that is heard by the presiding judge, and if the presiding judge is not available, then the presiding judge has to designate someone to hear that stay or that petition for stay. And more often than not, you'd be surprised, those do get granted and then eventually set for hearing. But they can be a very effective tool to minimize detrimental actions being taken by an opposing party. And then finally, before the final petition that we're going to talk about with regard to the Recon unit is a petition for removal. And as I mentioned before, those can be filed from only non-final decisions. And again, those are typically your discovery type orders. And the threshold requirement that you have to, or your burden of proof on a petition for removal, is to demonstrate that you will suffer substantial prejudice or irreparable harm. One other ground is bias on the part of the judge. And that can be a very high standard to meet. In fact, petitions for removal more often than petitions for reconsideration are dismissed or denied because of that high standard. And finally, one other consideration and very important point is that the filing of a petition for removal does not stay the proceedings like a petition for reconsideration does. So if you get for example, this is where a petition for removal often comes up. A case is set for trial, the judge issues an order in the minutes of hearing that you don't like, and you want to challenge, you file your petition for removal. Well, that case can proceed to trial before that petition for removal is heard. And so there are other grounds you can, or other efforts you can make, such as going to the presiding judge. In fact, I believe the trial judge is obligated to go to the presiding judge when a petition for removal has been filed and the case is set for trial. But it is within the trial judge's, or the presiding judge's discretion to decide whether trial can go forward. And so above the Recon unit, we have further judicial review. And the next level is a petition for writ of review with the Court of Appeal. And again, because we're filing a writ of review, it requires a final board order. And that petition has to be filed with the Court of Appeal where the petitioner resides or where the case originates. So if you have a case that originates at the Fresno board, then that petition must be filed with the 5th District Court of Appeal in Fresno. And just as important as the 20+5 with petitions for reconsideration, you have 45 days to file a petition for writ of review. And that is a straight 45 days from the issuance of that decision from the appeals board, and there is no extension for mailing. And finally, when the appellate court, our appellate court decisions are final 10 days after the filing of the opinion, unless a writ is granted. And what that means basically is if the Court of Appeal just outright denies your petition, which more often than not is what happens at that level, you have a flat 10 days, or a straight 10 days, to file your petition for review with the Supreme Court. That's a very tight deadline. The only exception to that is if they grant the writ. So what happens in that situation is they will grant the writ, they will set it for oral argument. Once oral argument takes place and the court issues its decision after oral argument, you actually get 30 days plus the 10. So the decision is final 10 days later, and then it's 30 days later after that that your time to appeal runs. And the grounds for review on a petition for writ of review are very similar to those for petitions for reconsideration. And this is from Labor Code Section 5952. The appeals board acted without or in excess of its powers. Again, a jurisdictional argument. The award or decision was procured by fraud, or the award or order is unreasonable. And finally, the last two, the order, decision, or award was not supported by substantial evidence, which is the most common grounds for appeal. And if the findings of fact are made, such findings of facts that should read do not support the order, decision, or award under review. Now, let's say the Court of Appeal denies the petition for review or writ of review. What's the value of that decision? Well, a writ denied case stands as a final board panel opinion that the Court of Appeal did not see fit to disturb, and it is citable authority. And again, it's not binding, but it is persuasive authority on trial judges and the appeals board. When the Court of Appeal does grant a writ, as mentioned before, they will request that the parties, or ask the parties, whether they want to have oral argument on the issue. More often than not, one side will request it, and if they do, then you better believe it, you should show up to argue your case as well. And I've done that several times, and each time is very different. Many times you will get no questions from the court, and in the times that has happened, I've found that the decision has been favorable when you do get a lot of questions, that can sometimes be an indication that they've got a problem with your position. Once oral argument is concluded, the matter is then submitted, and the court has 90 days to issue a decision at that point. And decisions are in the form of a written opinion, either affirming or annulling the board order or remanding the case for further proceedings. So they can do much of what the appeals board can do on appeal. Some other considerations as to whether to appeal or not by means of a petition for writ of review, and I get asked this question many, many times, what is the chance of making bad case law? Oftentimes, because of the general outcome when you're filing for a writ of review, the potential for bad case law is low because they will more often than not deny the petition. There is a chance, though, that if you file a petition and they grant the petition and decide to hear the case, that they could issue an adverse opinion, and then you've got your name associated with that case, and many clients understandably don't want to have that happen, and so that is a very valid consideration. And so many times, along with that consideration, I'm asked to assess the likelihood of success, and so that certainly is one of those considerations. But the factor that really weighs on my mind is that when making that determination or assessment is what is the ground under which we are appealing. If it is simply a substantial evidence argument, then there are other considerations to consider, which is certainly not last, but if you file on the ground that the decision is not supported by substantial evidence and the court finds that it is supported by substantial evidence, then you stand a chance of getting hit with additional attorney's fees, and that can run you, close to $8,000 or $10,000, depending on how much time the applicant's attorney spends in preparing the answer to your petition for writ of review. When a court of appeal takes a case, they can do one of three things. They can order that the decision be published, which is the highlight of every appellate attorney's career, and they can partially publish their decision, where some of it is not published, some of it is. I've had that happen as well. Or they can simply order that it not be published. And that was the outcome in my death case at the Court of Appeal. We lost at trial, lost on reconsideration, and got a reversal from the Court of Appeal in this death case. And they ordered it unpublished, meaning that it would not be binding authority. And so we petitioned the court to have the decision published, and which is something you can do. And they kicked it up to the Supreme Court, at which point in time applicant's attorney had filed a petition for review with the Supreme Court, which resulted in the court taking the appeal and hearing the case. Published opinions are an opinion that must establish a new rule of law or resolve or create an apparent conflict in the law. And so that's the standard as to whether the court will publish a decision or not. Unpublished decisions cannot be cited at all or relied upon by a court or a party in any other action or proceeding. And that's a good way to get yourself sanctioned as well, by citing to unpublished decisions in your own subsequent appellate work. One way to avoid that, though, is to creatively borrow from the Court of Appeals decision in an unpublished decision when drafting your own argument. In addition to petitions for writ of review, there are petitions for writ of mandate as well. And just like it sounds, you're asking the court to mandate or require the Court of Appeal, or the lower court, sorry, like the WCAB, to do something. It's specifically authorized by Labor Code Section 5955. It's not something that is frequently used, but it is something. It is a venue for appeal when you are dealing with a non-final order. And because you're dealing with a non-final order, you must file a petition for removal as a prerequisite for a petition for writ of mandate. And then finally is the Supreme Court, which is the end of the road for workers' compensation matters. The Supreme Court will issue their decision, or strike that, sorry. When a decision from the Court of Appeal issues, and after oral argument, like I mentioned before, the timeline to file is 10 days, at which it becomes final, and then 40 days to file that appeal. And the losing party is typically the one that files that appeal. The grounds, again, for review by a Supreme Court are very different from those by a Court of Appeal or the WCAB. And there are 4 grounds for review by the Supreme Court, but only really one will apply to workers' compensation cases, and that is the first one. And it is a very extremely high standard to meet. That standard is, when necessary, to secure uniformity of decision or to settle an important question of law. And the first part of that phrase, to secure uniformity of decision, typically means that there are 2 different opinions from 2 different lower courts of appeal. And so when you've got a conflict of law, essentially, between 2 lower courts of appeal, the Supreme Court will grant review of one of those cases to explain what the law is or what it should be, and thereby make that decision uniform across the state. And when and the other ground, or the other part of that phrase, is to settle an important question of law, and that's usually where you will get the court to look at this issue. And so you've got to raise a question of law. It cannot be a question of fact, or else the Supreme Court will simply dismiss the petition outright. And that is, when I was talking about other considerations for appellate review at the Court of Appeal, that is really probably the most important consideration, is, are you raising a question of law such as statutory interpretation or how the law should be applied? And that is something that will garner the court's attention and significantly raise your chances of the court taking or hearing the case. And then finally, once the Supreme Court, when they hear a case, they have 60 days to grant the petition, or they can extend it on its own motion. If the petition is granted, the court may start the appellate process over again with oral arguments and issue an opinion and decision affirming, reversing, or modifying the decision of the Court of Appeal. And it's more common for the Supreme Court to, when they are explaining what the law should be, simply remand it to the Court of Appeal with instructions to conduct further proceedings. And then you've got the clock running all over again, basically, at that point. So that takes us all the way through the Supreme Court and concludes our presentation. It's been my pleasure. Tammy?
Yes, thank you very much, Louis.